You are live.
All right. Looks like we're live. Good afternoon, everyone. This is Judge Fonseca, your judge at the 464th District Court. And we're here to talk about the Supreme Court as part of our open forum series. We're bringing you this topic, which I think is very important because the Supreme Court decisions affect our daily lives. And I've asked two well-known and respected attorneys in our community to come on and talk about what the Supreme Court has done, a couple of cases. Obviously, we would be here for days if we talked about everything the Supreme Court has done this past year. But we'll pick a couple of cases to talk about. So let me introduce you to our guests. First, we have Pablo Almaguer. Pablo, if you could please introduce yourself.
Sure enough, Judge. Pablo Almaguer from Work Your Local Legal Aid Organization. I'm here on my own as somebody interested in having this discussion with a judge, a 22-year attorney here in the Valley.
We also have Victor Flores. If you can introduce yourself.
Hey, Judge. Yes, thanks for inviting me. I don't have as much experience as Pablo, but I am a municipal lawyer by practice. That's what I've done. So I've represented cities in Denton and Plano, which I just came back from. I'm back in the Valley, but also before I left to North Texas, I was assistant city attorney in McAllen, and I've also advised Rio Grande City as well. So mostly municipal law, but just a constitutional law nerd as well. And when I heard that Pablo was going to be on, I said, sure, definitely. He didn't say it himself, but ran for state bar president this past year, and just I don't mean to open old wounds, Pablo, but
that's okay.
But barely. I mean, it would have been great for the Valley. It would have been great for the Valley for sure.
Thank you.
He did make a great run, and the entire bar. I'm sure I'm speaking for the entire bar in Hidalgo County that we are proud that one of our own was able to get that far. And I hope you do it again. I'll just pull the plug. I'll just say that.
Thank you. I appreciate that. Yeah, I didn't want to go too attached.
All that will the bar in general will be of great benefit to have you. It'll be a great benefit to have you if you run again. So we have a couple of Supreme Court cases that we've kind of picked. We picked them ahead of time because there's heavy reading involved on some of these cases. So if you call in and you leave any comments and ask questions about other cases, I can't assure you that we'll have answers because we haven't prepared for that, not because we don't want to, but because reading Supreme Court decisions require studying them and looking at the facts, the procedural history, and ultimately what the holdings were from the court. So, but I'm sure there'll be someone that's going to ask a question that's outside of the scope of today's discussion, and we'll try to. I'm not dissuading anybody. This is an open forum, so make sure you ask the questions that you'd like as we go along. If you come up and think of something, please leave it in the comments, and we'll try to get them to you. So the first one we're going to talk about is Guadalupe.
Yes, yeah, we'll save the 200-page opinion on Bostock for the end, Judge. Yes, Our Lady Guadalupe School versus I believe it's pronounced Maurice Baru, right? So this case was actually two separate cases out of California, out of LA County, consolidated to be heard before the U.S. Supreme Court. With a focus, right, on the issue of the ministerial exception. This case was really interesting to me because I've advised my local church when I was back in the Valley before, and so very familiar with this exception.
What is the ministerial exception for people who aren't lawyers that are watching? What does that mean?
Right. So it starts off with the principle, right, that government shouldn't be involved in deciding who a church hires to teach religious studies, kind of that separation of government and the church. But but this case was, I think, was tailored towards, does that ministerial exception apply to teachers who may or may not, right, teach religious faith. And so I'll kind of go through kind of the background. So there were two cases that were combined. The first one was not named in the lawsuit. It wasn't the head lead name a party for the lawsuit. It was Christian Bale. And Pablo, I know you have a couple of daughters, and for those viewing and aren't attorneys, that Christian Bale, not the Christian Bale, Pablo, from like Frozen, right? Because I know you have that Frozen song, right? It was Princess Anna. This is a not as well-known Christian Bale. She was actually a fifth grade teacher at St. James School in Torrance, in California. And Kristen worked there at the school for multiple years as a lay teacher. She went on to become a long-term substitute teacher, and then finally a full-time teacher. And so the school canceled her contract shortly after she told the principal that she had been diagnosed with breast cancer. And so she sued under ADA. Unfortunately, just kind of history, more background on it. She passed away due to complications, I believe, and her husband, Daryl, maintained in that lawsuit. But Agnes, so the name party in this case was also a fifth grade teacher out of Our Lady of Guadalupe in Hermosa Beach, California. And after teaching, years there at the school, the principal said, "You should probably think about retiring." And she wasn't ready to retire. So shortly after that, the school just didn't renew her teaching contract. And so later she sued under the Age Discrimination Act. But in both cases, for the purposes here, we treat them as one. The lawyers for the Catholic Archdiocese argued that those lawsuits should be dismissed under the ministerial exception. And so that kind of has a history, that the ministerial, like we started our conversation, has a history, and on two principles respectively, that one, religious institutions should determine for themselves matters of church government, faith, and doctrine. And second, the courts are barred from entertaining employment discrimination brought by religious school teachers. And so in here, the case before the Supreme Court took special account as to whether that ministerial exception applied more broadly to teachers in a church-run school whose primary duty was not necessarily religious instruction. And so the way kind of Pablo and I split these up was that I'll kind of provide this background for the cases, and he's going to do a lot of the heavy lifting. And maybe Pablo, if you could kind of explain a little bit more of the court's analysis about how they dissected those concepts about ministerial exceptions.
Before we get into that, just so we can explain a little bit more, the ministerial exception, the word ministerial, because we're looking at before. We were looking at the minister, the person that is preaching or teaching religion. Pretty much what constitutional law says. Well, government can't get involved in who the church is hiring or putting in front of the pulpit to teach what a religion believes. But now in this case, we're talking about people that work for the church but don't necessarily have anything to do with teaching the faith, right? That's
correct.
Okay.
That's correct. And I don't know the audience here, if they're attorneys or not, or lay folks. And I got to distinguish, because there's two very distinct cases here in interpretation. This is First Amendment. Everybody knows about the Establishment Law, which is a clause. And there's a historical perspective behind that. The next one we're going to talk about is Title VII, which is an enactment of federal congressional law. It's a different plain meaning interpretation. And as we know from law school, and I think the layperson should know, when you come to like certain fundamental freedoms, when you come to the First Amendment, when it comes to like certain issues, you have a standard that is met because it is enshrined in an amendment. It's got history behind it because the Bill of Rights and the amendments come with part of our established, history here in the U.S. And in this one, they have a description in the beginning, have an analysis, not only about the precedents, about the ministerial issue, but the history, why it is that you want to separate the church from the state. They talk about appointments, in English times, by political appointments by religious, persons. So you would commingle the both to basically establish, one religion based on politics. They didn't want that. The founders didn't want that. Yeah, and that's the history behind it. Such as a very strong amendment that gives this very close scrutinizing, if you will, without using strict scrutiny, of these laws, when you apply them. And so there's always sort of like a carefulness about it. And Judge, who passed away, Judge Scalia, was very careful about this First Amendment. He was strict about it. Alito actually wrote this opinion, and he's probably the closest to him in the harshness that he can impart his intellectual, decision making. And he starts with, of course, with the history, and then the analysis. And you're right, Judge. The issue here was that the case law that existed before this said that if you name a title to somebody, matters. If you're labeled as a minister, then obviously you've got a religious, activity. Then these federal laws shouldn't impinge upon your duties. And the reason is because you don't want to commingle the both. You don't want the church to influence the state. You don't want the state to influence the church. You want it to freely and not just any church, any religion, to have it freely flow. And the previous precedence was that maybe a title would then, a ministerial act would make it that, and you should, the federal laws wouldn't apply to that position. This case law then expands it a bit further than that, and explains that it wasn't a hard and fast rule. It was actually several different factors that come into play. And what they looked at carefully here is that in both situations, there are employment contracts, if you will, that required teaching, prayer, certain non-secular activities by the person and the individual, both teachers, which then I think was important for them. And they said it's that intent within the contract and what the people agreed to that's going to matter along with the circumstances, and not just the title alone. And it was almost kind of harsh in the treatment, that Alito kind of said, don't depend on the title itself. To critique that a bit, some, and you people, the folks listening can argue with this. For as an attorney, I read it like the precedence was not precedence. Here is a new one, and it kind of expand. I felt it was a bit trying to fit into this model of what to get to a certain decision. And I see that because he also listed a litany of different kind of religious and examples as to why there needs to be this sort of freedom. But as a legal aid attorney who represents plaintiffs, if you will, who sue employers, if you will, the one thing that kind of carried heavy with me, and we can go into more details in part of the holding, but what carried heavy with me was how much power then the employer now has to establish the contract and the terms that can include any religious, a prayer for a certain time or religious tone to it. And then that clinks in the waiver of the federal laws. So they can actually discriminate because they have it in their contract. What kind of bargaining power is there for the employee to say, what did I get for that, for waiving my rights? So I wonder, if an employee relationship can be, if in the future an employee can say, well, if you're going to ask me to do this and waive my federal rights, what do I get in return for this kind of consideration, for that? That's not addressed here, but I saw it in that employee-employee relationship. That's a really brief overview.
Right. And I think one of the questions that really, not as a judge, not deciding whether it's good or bad, but just a question that comes up because of this holding is, do we really just take any employment with a church at all, with any sort of entity that's related to a church or a religion? We now treat those jobs as effectively being exempt from any federal protections that we've been having in the last 100 years. Victor, do you want to weigh in on that?
Right. I mean, think, and I don't know if it's maybe because I'm just thinking, I keep on going to my own personal experiences, and so I'll just share it with that, right? So I'm I'm Baptist, right? So I'm part of a Baptist church, and even within the denomination, they're making changes about who can teach, right? There's a whole debate going on, like who can actually teach, or I would say preach, right? Teach and preach, those things. But you have different ministers. You have ministers over, Sunday school, or different kind of children activities, or worship minister, or different things like that. Then you have like Bible studies, and so where does that, like you're saying, Judge, like where, is it everybody just because they're employed by the church, or is it maybe this more like a preaching I guess I would say it that way.
I mean, as lawyers, we try to put the facts in the way most favorable to our client. And a lot of people may not know, but for 8 years, I was the lawyer for the Basilica of San Juan here in Hidalgo County. And a lot of the things that, for example, people that put together the candles that would be sold and people would put at the altar of Our Lady, it was all done in house. So are they part of the religious aspect of the basilica, which is encouraging people to go and pray and purchase these candles? And I mean, I would make an argument that, hey, they're an essential part of what this church does. The candles. There's a whole room in the basilica dedicated to safeguarding the candles that people light because it represents their prayers. So the people that are involved in doing that, they're not teaching, they're not preaching, but they're an essential part of a religious practice.
Right.
And to the closest extent that there's a holding that you can probably kind of state forth, and there is of course a very strong holding in Our Lady of Guadalupe, is that it actually does say, to your question, Judge, there's a Hosanna, which is the ministerial title, holding, plus 4 factors that it talks about. So in your situation, talking about the person takes part in the integral processes to respect somebody's faith and lights candles and otherwise, you apply these tests. You see the title itself, then you look at training and commissioning, the training of the person and what they did, how they hold themselves out, if there is such of a ministerial or kind of religious purpose, and the job duties themselves. So what you're saying, I think, Judge, there, it does lead to the fact that it's part of the whole to be, exercise your religious freedom. But the person themselves, is there really a specific religious training to learn how to light the candle? No. There's a certain kind of, training involved to maybe teach somebody a certain kind of like theology. Yes. Interestingly enough here, though, in these 2 cases, both teachers did not have any kind of religious training. There were secular universities, secular degrees. There weren't liberal arts. There weren't anything religious. So I found it interesting that it was addressed that even though that religion wasn't studied by them, they chose then to have to teach religion by choosing the job, as to the way Alito wrote it. I don't know if I can agree with that. I think it'll be interesting in applying the test. Did they come in thinking I am from, a Jesuit, college, and I want to continue that kind of distinction or practice? And it wasn't the case here. And the harsh part about it, if you want to apply the facts too, and I have to say it as a legal aid attorney, you have a lady who's been there for quite a while who wants to retire and got fired. You have a lady who had cancer, and because of her cancer, took some time off to recover and was fired. That's harsh. I mean, and I can't combine the both in the factual sense, not to fault the court here, but just the inequity involved there in saying that there is a need to have a certain amount of respect for religion and purpose and the involving of faith, in a person. But then those kids now know that the teacher that was older and the teacher that was sick from cancer got fired. That's difficult to take. In my opinion.
Well, I think you see the philosophical spectrum on that from the Supreme Court, right? Like you have some who are just, like Scalia, has passed now, but others that are on the court that are strict, just they interpret the law as it is instead of considering the equities, right? The consequences of a holding like that, because that is pretty harsh, right? Like, I mean, that's
and we're talking. Go ahead, Judge.
But isn't that contrary to Scalia? I mean, in a sense,
yes.
Is he? I mean, I see him living through Thomas and Alito.
Yeah.
They're still continuing on with his legacy and his judicial philosophy. But the holding in this case seems to go a little further than what Scalia would have done. I'm a big Scalia fan, but maybe I see it as an affront.
You think so, Judge?
Scalia. I think so.
Yeah.
I don't know. I don't know what your take
I mean,
is.
this is a 7-2 decision. This wasn't like a 5-4. So there's a couple of liberal, justices that fell. And I think you talked about the third part of this discussion is going to be about Justice Chief Justice Roberts, because I think personalities have to sometimes have to deal with it. There even is an autobiography you can talk about that in Chief Justice Roberts. But this is a 7-2. So there were two what considered to be the liberal wing that came over to this end.
Was it Ginsburg and Sotomayor?
I don't remember at this point, but
it was.
I think Sotomayor is the one with the dissent, and she was harshly criticized by Alito about smoke and mirrors and interpretation, which is very much a Scalia way to just kind of do you in. And listen, it's going to be hard for me to be consistent in the next discussion about the plain meaning of the rule or the law, and not say that my constitutional law professor right now would probably want to hit me over the head and say, "What are you talking about in the emotional, factual side and the effects of this? What is the law?" And there's some benefit to, gotta say, to have a judge that says, this is a wording, the outcome is harsh, but this is a wording. How can we give you as a citizen of the United States, somebody that follows the law, fair notice of what it is, if we're changing it around based on the emotions and the motives and the feelings? So for that, I got to respect the rule, right? And then I have to, and I follow it, right? It is that. I just wanted to point out, though, sometimes the harshness of the decision, and that maybe in a strict application of constitutional interpretation can lead to this. For the layperson, for the attorneys, I think, we all know this happens often.
I personally had trouble understanding how they got there. I don't know, Victor changed my mind.
No, I'm not going to disagree with the judge.
No, it's
no.
Yeah, I was really, really shocked that you had this kind of majority, and with the result, it seemed like the test was the way it was applied. Maybe it's the way it was applied to the facts that having a problem. Maybe it's not the test itself, but the way it was applied.
Right, I think so.
You can, the court creates tests all the time, right? These are the elements you have to follow, and this is what you look at. And maybe, I'm not saying that's how I feel, but like Pablo says, they knew what they wanted, and this is how they come up with. I don't want to put words in your mouth, but this is what we wanted to happen, and this is how you get to that.
It is that way. And by the way, if you read the concurring opinion by Thomas, he goes further. He gives, I think it's a matter of discretion being given to the employer here, that this opinion respects. And Thomas just says it. I mean, the employer says it. I mean, the religion, the church says it. And I guess you have to, on one end, I'm going to argue with myself on this one. On one end, you've got to respect the establishment of religion. I mean, it's just a historical basis. The reason that, many of the founders, left, from England and other places for their religious persecution of it. So it's very strongly ingrained in the history of the United States. But then at the same time, though, I wonder how this can be misconstrued, not just by the attorney, but the layperson. Like, you hear it now. I don't want to wear a face mask because of my religious freedom. No. That's not what this decision said. But I think people now have it in their mindset, like, let me click, and if I can say a religious, exception, the courts are going to find me a way to get out of that, federal law or state law. That's a mistake. That's completely inappropriately applied. And I think the difficulty of finding the hard statement and holding on this matter is what gives, I think, me at least, that insecurity as to what people are not going to be able to just take it and use it as they want.
You want to say something? You want to say something?
We're going to lose your audience, Judge. We're getting really kind of serious here. We're going to dark.
I know. This is what I want. This is what I want. This is the people that enjoy constitutional. This is you. It was a good call.
I don't enjoy this one. I'm going to enjoy the next one. I'll enjoy the next decision.
So people know I was thinking we were going to talk about all these cases, and then I thought about it as Pablo and Victor came back. Like, we're looking at these two, they were a lot more grounded in the fact that we can go on and on about these cases.
Yeah,
we
and have some good back and forth with it. Yeah, that's
right. We can't possibly talk about 4 or 5 cases in 1 hour. But yeah, so there are a lot of there's some concerns, and I think people can understand what it is that we're saying, and what the court has held, and obviously we respect what the court does as lawyers and myself as a judge, and that's how the law is going to be applied, and that's what the test that the court set out. That's what I'll use if I ever have to rule on one of those questions.
Yeah.
So
Yeah.
they're called the Supremes for a reason.
Yes.
So
Yeah.
so
Should we go into
yeah,
Bostock?
let's talk to the next one.
So we're going from California out to Georgia now, right? So and Judge, I like getting to know, because some people think like lawyers, like, how can you get so into these cases? Well, there's stories. There's stories about real people, right? This last case we talked about 2 teachers. This case is about a child welfare advocate, skydiver, and I think the other one worked at a funeral home, right? Of course, the named party, the Bostock, Joe Bostock, he was actually the one who was the child welfare advocate. The background for him, he was an employee, long-term employee. I think the story is, the background is, he was recovering from some kind of cancer and joined a gay softball league. And so shortly after that, he was terminated. I think after this, the same thing with the other 2 parties. The other 2 parties, similar situations happened where it was made known that they were gay, or I believe the last one was transgender, and so their employees said that was unbecoming of their organization, of their business, and so they were fired for that. And up until this case, it wasn't clear whether Title VII applied to that demographic, to that group, to the LGBTQ community. And so in this case, the Supreme Court, I'll just cut to the chase, the Supreme Court did decide that an employer violates Title VII, which makes it unlawful to discriminate against an individual because of the individual's sex, by firing them for being a homosexual, being transgender, a transgender person. And so for the LGBT community, it was a big decision. And so I'll kind of let Pablo go. I think there are a couple issues we can go with here, Pablo, but I guess I'll just let you take the lead on that.
No, thank you. To mention something interesting though about the effect of this decision, I want to mention that fairly upfront because it is big and momentous. It applies to the federal law, of course, Title VII, right? You have to have 15 or more employees in order to be applied. So if you have 15 or less, it wouldn't. Apparently, that's like 20% of the workforce in Texas, from what I understand here when I read some of the facts here. It's a pretty wide applicable, issue. And then now with, I guess the more comfortableness of the LGBT community, coming out, and stating, their own statements, about their identity. There's more and more in the workforce that are part of this, 20%. So this is pretty momentous. This is big. A little minor thing, Gorsuch wrote this one. He's a Trump appointee.
Yeah.
Enough. I don't know if you know this, historical history here, or Supreme Court, Kavanaugh and Gorsuch were both Kennedy clerks. I don't know if you all knew that. And Kennedy is always at swinging votes. So I'm wondering who influenced whom there, and because they both have had that issue. And Gorsuch, this is an opinion. It was just, it's pretty beautifully written, I thought. When I was reading it, when it first came out, and it was a while when I first came out, I was like trying to see what the whole thing is, and I go, it looks good. I think it looks good so far. And they mentioned, of course, the watershed case of Price Waterhouse, and page 9 of the decision talks about an individual employee's sex is not relevant to the selection, evaluation, or compensation of employees. And then the next paragraph, this is critical. This is where it kind of blew me away. an individual's homosexuality or transgender status is not relevant to employment decisions. That's because it is impossible to discriminate against a person for being homosexual or transgender without discriminating against an individual based on sex. And those words are strong right there. That expanded the law. And once I read that, I was like, okay, this is going to get interesting, because that's page 9 of like 33 pages of opinion. And what's amazing that after that page, if you look at the decision, it's not until page 12 that he cites another case again. So there's 3 pages there of establishment and interpretation of what this decision means without, constant citation. Like you had in the other decision, you had samples in other cases there. And that's incredible. There's some cases out there that you would never look at Brown v. Board of Education. Very few case sites, and also interesting, the effect of it. But I think it's just when you expand the law, when you expand interpretation, if you will, or you interpret it, it's interesting to see the court, take that and say, here's the application of it. And that's what the issue was here. This is not a First Amendment issue. This is not a Bill of Rights issue. It's a law created by Congress, created, back in the 60s or so. And so then the issue here was, what does the law mean or say? Plain meaning rule, a strict interpretation here, as you would, and the Scalia sense, if you will, sometimes.
I take issue with that, but
well, it's your show, but
no, go ahead, Judge. What? Yeah, I guess.
I don't want to interrupt you. You were setting the stage for.
I was so good. I was going into it, and then you just no. And I'm saying so. I think the 3 or 4 pages of statements there, without citation of law, is an application of the plain meaning, rule. But for what it's worth, I didn't see a straining of the definition. I see a strict application, in my view.
Victor, do you have a different view?
Well, no, I'm just going to add on to it. I think, Pablo, right? Like, I think for the nerds watching, right? Interpreting cases, it goes at length, right? Like the court goes at length to describe what, the ordinary meaning of because of is because of, right? And the court goes on.
But for.
Right. Yeah. But by reason of, right. And so I would just add that this is a case where the court really dives into interpretation, but like all Supreme Court cases, it's not. I think society in general kind of looks at the court and says, that they just they arrive at the decision. We kind of sit around. They arrive at the decision they want to make, but there's like this academic exercise in evaluating some of these words and really trying to interpret what what Title VII says about sex in that context of LGBTQ. So I know we interrupted you, Pablo, but go ahead. Continue.
No, it's the judge's turn. I think we've set it up.
Well, when the court has to go through explaining itself, and you're no longer rooted, then I don't see that as being originalist or as being a strict interpretation. At that point, if you really have to explain yourself, it's not. That's when I start taking an issue with the Supreme Court's decisions. Just speaking generally, and not getting into anything in particular, but why do you have to take that much? If you're really just interpreting the law, then why do you have to explain yourself so much? Now, I understand that's the first thing that I think of, but I understand that you do that as the court so that because it's a momentous decision, it's a big decision that's going to have a big impact on the law and how we apply the law. So I see why the Supreme Court does it, but when I first start reading things like this, I'm a bit skeptical because if you're an originalist and you're looking at how things are written and how they were written at the time, then that's where the conversation goes. And I didn't see that in this decision.
I think you also have here strong dissents. And I think just like Alito Guadalupe, you have to kind of address them. Alito did it in footnotes, but I think in here they did it right on the page. And you do see, you're right, Gorsuch did take a very detailed approach. He talks about the law itself, the history behind it, the expansion of it, the but-for discussion, then the application, but also then goes to great length to like go through each one of the employer's arguments. And it might seem like it's a very enduring kind of a long drawn out decision, but if you're going to have a decision that's going to create, and expand or clarify the definition, if you will, of Title VII, I think employers need to probably be given a certain notice of saying, you can't do this, you can't say this, you can't do that for an argument to bring before us. And I think that actually might make it a better decision, in my opinion, Judge, so that we as employers, the counsel from both sides can now know, okay, you know what, this was addressed in this decision. It was right there as plain as day that we can't go, and because we treat the whole class of sex one way, it's going to be fine, or because people in conversation think of this differently. He went through that, so don't come back to us with these issues. This is where the law is. That's the way I saw it, Judge.
Sure. And I'm asking questions to generate discussion, and the issue, not necessarily what the holding is, but how you get there. And if you used the word expand a couple of times.
It's interpret, discover the definition, Judge.
So and that's how I see it. That it looks like an expansion of a definition.
Yeah. Well, I agree, Judge. I was just thinking right now in maybe bringing the two cases together, right? Because I think you have heard some, discussion out in the public about, well, what does this do to religious, religious convictions, right? And I think Pablo, correct me if I'm wrong, but the court did kind of say like, yeah, like this opinion doesn't preempt the religious exception, right? Like we were just talking about with the ministerial exceptions and whatnot.
No, that's different. And let me clarify on what I've said there, and I caught myself doing it. An expansion of the class protected. That's what we understand, and we have to kind of learn that in our practice to remember and have that in our mindset. And then we can go into this later on, but we have a legal sort of philosophy class in law school, that I liked and I have to apply here. And I got to say, the legal realist might say what we said here, you want to reach an outcome, you get to it this way. But I think here you have interesting writing by a judge that I thought was very clear in the way that the plain meaning rule, as established as it is, what it is and what it creates. There's a great quote that the judge cited on page 24, actually from another case on them. Just because there's a definition and it wasn't there before doesn't mean that somehow, you've added more to it. What he says is that the fact that a statute has been applied in situations not explicitly anticipated by Congress back in '64 when it was enacted does not demonstrate ambiguity. Instead, it simply demonstrates the breadth of legislative command. And that's important because '64 is a momentous law. It's a momentous time, when that happened, when it was established. So if you carry forth that effect and understanding of the writing of that law, and it's still, expanding the classes, I think I see it then as sort of like that has always been there. It just hasn't been interpreted and defined clearly until now. And that's also, of course, another form of constitutional and legal interpretation. You talk about penumbra and what's clear and what's not.
I was going to use the word penumbra right now. Take that word out of it.
Whenever you can.
It's because it's and that's my issue, because we're looking at what law we pass now. It could evolve, and for those that look at judicial philosophies generally on the Supreme Court, we have those that believe in the Constitution being a living, breathing document that evolves as our society is evolving. And then you have the originalists, strict constructionists on the other side, which I may lean a little bit more towards in looking at constitutional issues. This is not constitutional; it's a statutory interpretation, but I think you can apply it the same way. And that's where I have I raised my eyebrow in how Gorsuch got to this decision, because in 1964 we weren't really looking at transgender people the way we're looking at them now, and it's the discussion's completely different now as it was back then. So that's
Yeah.
that's my beef.
Well, yeah, Judge, but it also didn't look at the pregnant female, and the status that creates too, back in the 60s or so, and how that was expanded too. I think, I don't know what causes what, right? The causation here. If the law being established then causes an acceptance of a certain class, if you will, I think that as society and norms might change, it's a clear understanding that, what, this law was written here, it actually applies here too. Not to expand the definition, but to realize this law actually protected this class. And we've just kind of been singing this all along. We've been, on our own sense, discriminating because of our norms. Once those are debunked and done away with, and you have a clarity here, you think, what, this falls here too. Whether you're a pregnant woman, it's because of sex. Whether you're age, it's, because you're discriminating because of age. And now, you can't deny the fact that your identification in one or the other, male, female, or otherwise, is because of sex. So I see it as a sort of like a maturity now of the understanding of our societal norms, if you will, or societal understanding of each other, that then realizes this law actually is more than what it was originally. It's more, there's more there than I think we've seen before because of what we see now, if that makes any sense. And that would never hold any kind of holding in any kind of law there, but that's what I would say.
It does, and I think that's the target or the bullseye on differences on philosophies of
Right.
how we interpret constitutional law.
Right. I wanted to add about, I think I was looking here at Alito's dissent. He goes on to think, he was talking about the consequences of the court's decision. I think he says, although the court does not want to think about the consequences of its decision, will not be able to avoid those issues for long. Entire federal judiciary will be marred for years in disputes about the reach of the court's reasoning. Now whether he's pontificating, going on and on, which justices from time to time do, to drive home their point. That goes to the question, right? I mean, should the court in its decision really think about the consequences, or should it just be the umpire calling balls and strikes? I think for the appellate level, it's a little different, but yeah, I guess for the group, I mean, what do you guys think? Should the U.S. Supreme Court really be taking into consideration the consequences of their decisions, or just be trying to make a
tough question, I think.
What time is it? I gotta go. You're right. So let me tell you one thing. The decision by Alito was lengthy. I mean, like 70 some or something pages. It was crazy long, and it actually has a lot of a big appendix. Like Judge, you mentioned that there's bending backwards here of interpretation that the majority opinion does. I think we've got a 70 some plus page opinion with appendici, I guess. I don't even know how to say the plural now of it. You really are struggling there to make your point and to go back to the decision that he wrote, just because, it's part of the Gorsuch decision. I mixed them up here completely. Just because in conversation you feel a certain way, it shouldn't be necessarily that you're not discriminating. You should pay clear attention to what you're saying. And it's probably discriminatory. Gorsuch talks about that. And I can't help but think that all these examples that Alito provided is that in a sense kind of upholding these stereotypes we thought we believed in? And why you have to put so many examples into it. So I find it very difficult to have to go through all those examples when if it's there, it's the law, cited. Tell us the precedents, tell us the case law. And not give all these examples that might be based on certain stereotypes and misconceptions.
Going back to your question, Victor, a court, whether it's a trial court or an appellate court, should be calling balls and strikes. I think obviously the Supreme Court has a much greater role because it needs to interpret sometimes things that we didn't think were possible, that were going to come up, very specific fact patterns where law hasn't been applied in the first for non-lawyers, it's a matter of first impression that the Supreme Court gets to look at and considers how it should be interpreted. But that being said, we also need to look at what the consequences are, because it sets the precedent that's set by the Supreme Court. It affects generations. We can look back at several decisions by the Supreme Court, and how they've lingered. I mean, they rule how we look at things. Not to get controversial, but let's look at Roe v. Wade. I mean, how long have we been having that discussion about Roe v. Wade? Because it was a momentous decision, and it's still part of our discussions in the political arena. So, I mean, that being just one that just popped in my head, obviously, because it's a very controversial one. So it's the Supreme Court should maybe take that into consideration. What are the consequences? So that being said, in a decision like this, isn't it just best left for the legislature to take care of? That's what I think.
They did in 1964.
Yeah.
We just found out about it now.
And to both of your points, I mean that's Alito's. Although he took 60 some pages, or how many, Pablo? Like
I don't know. I stopped at 50, man.
Yeah, but to get at that one point, right? He talks about even had any I think he said it. If every person in 1964 had been polled, that's just not possible, right? So it's I think this goes to kind of highlight why just a plug why it's important to be aware of the judges that aren't just elected, but also are appointed, because they come in with their perspectives, right? Not that any one judge or justice comes with bad faith, but they come with their perspective on life, and I can't imagine that in interpreting. It's painted. It's tainted with not tainted, but it's painted with that perspective, right?
That's a very difficult kind of skill to have to learn in law school. You have to detach yourself from that and apply what you see there. But it actually rolls into the last topic, and I don't know when you want to go into that, Judge. But I'm a big fan, of course, for many reasons, of the Warren Court. Earl Warren, and I have a biography about him, and what he's done. And
let's dive into Justice Roberts then.
Yeah,
because it's
it's part of this discussion here too. I mean, I want folks to understand that it's not necessarily right now. It's been happening for a while. And you can mention several different justices from before. Justice Hugo Black, great dissenter. Some of his dissents became opinions. He was actually had some racist affiliations before he came, which he apologized for when he came on the bench. So he could move on from what he had kind of learned where he came from, right? It's just the person is. Chief Justice Warren was a legislator, right? And he came to the court. He very much had a sense of what decisions what the decisions that they made, how they're going to change, the world. And some of the discussion that Alito would probably be had about his decisions. But like Brown v. Board of Education, he actually went, I think, to the bedside of one of the justices to make sure that they would sign off on it as a 9-0 decision, because he knew it has to be 9-0. It was going to be this momentous. It's got to move forward. And I can't help thinking that right now we've got the court is Roberts' court. And you don't know now where he's going to end up in. I don't want to call him a legal realist. I don't think that he kind of, is by the seat of his pants. But you look at the biography that was written, I think he's a very clever intellectual man. Who there is some horse trading, I think, that happens in some decisions, which might explain the earlier Guadalupe, a 7-2, and then having this decision being like, I think, a 6-3 decision, right? Where he moves to the other side. And how he's being careful in maneuvering this, the healthcare law a few years ago, how he, fell on that and that 5-4, I think, switch that had happened there. I think that explains the complexity of the person, understanding that apart from what we're deciding here, there's some consequences, and how do we then fit in these, and how do we fit in a form of government, as the judicial branch? Where do we fall in that? And I think Robert is taking a really clear position now to make the court above the fray of the political that's going on right now in the other branches. And I think that's very important to note. It's a very difficult position to do, but he's taking part in that.
Yeah, I pulled this up because it has a line in it that.
Wait, let me get my book. Let me get my book. That's a green screen, by the way, guys. Just to let you know.
But no, Paulo, to your point, right? So in his book, in the book, the chief, it goes on to talk about one of the quotes in I believe in 2018. Roberts is in this, speaking to this conference of judges, and he says, I feel some obligation to be something of an honest broker among my colleagues and won't necessarily go out of my way to pick fights. Right. I think that's what we're talking about here is as much as we want. I mean, I always, when I started studying law, the Supreme Court, like you want to understand that it has some like this purity to it. Like it's the last final hold on American jurisprudence, right? And so, but to hear that and to know that there's some, there's people broke, we have brokers on the court, kind of making these cases happen.
I recently read an article, I forget what paper it was in, about Justice Elena Kagan, how this could possibly be called the Kagan Court, because they see how she's kind of behind the scenes being a broker on cases, using her skills as a former law school dean in bringing together people. So I'm gonna look for that article. I'm gonna send it to you guys because it was very interesting, very different than what we're talking about here. But getting back to Justice Roberts, I remember hearing him talk about the making sure that the court was protected, or that not protected, but maintaining the integrity, or making sure, like you said, I forget which one of you said it, but making sure it was above the fray of politics. But has he gone too far in doing that?
I don't think so, Judge.
Okay.
I'm sorry, you didn't finish.
No,
I was saying I don't. Go ahead.
I see it, like, for example, there was and I know we weren't going to talk about this, but just briefly, the abortion case on the Louisiana laws. He had previously dissented in a case with almost identical facts concerning Texas law, and then we're looking at it from the perspective of the Louisiana law, and he sides with the majority in that case. He that kind of seemed to me like he's taking a step back. And
well, but Judge, wasn't he then just kind of telling the people, like, I know we've got two justices now here that weren't there before. You all got to stop this. We got to end it somehow. It's not said in that simplistic terms. That's the way I saw it too. And I got to tell you one thing. Maybe he is brokering deals. Maybe he is doing this back and forth, but it's in an intellectually honest, I think, way, in a very kind of, careful way, to respect opinions, of both sides here, I think, which is a quality that is completely deficient in both legislative and executive functions right now. And for a democracy, I think it's important for at least one body to remind people of the other ones that once in a while, you've got to go to discussion. You've got to have agreements and disagreements and come up with a better decision. And I think he's teaching the other two bodies about how to do this.
Well, Pablo, and don't you think it's like a piece of evidence of that is, I believe the president had made some comments about speaking out against one of the federal judges, I believe. And I think it was Roberts that came out with and this is uncommon, right, for a Supreme Court Chief Justice to come out with a statement saying, our courts, this is not an Obama court, it's not a Trump court. We are, doing our best to make independent decisions, not respective of any political party, right? And so I wonder, Judge, if you're saying is he going too far? And I wonder if maybe if he is, it's a result of having to counter, Congress or, the president, those actions.
Right, but if you're doing that, you're playing part in the partisanship and the political part that the Supreme Court's supposed to be staying away from.
Independent, right?
right? No?
I don't think so. I think there's a deliberation involved. You know, there's deliberation. Yes, the executive side is going to be deliberating and kind of having an agreement and discussion, you know, on the legislative side as to what he wants done, and then also kind of execute those laws that he has before him. The legislative, I mean, the Senate is described as the most deliberative body in the nation and the world, and it really isn't. Hasn't done a thing much in the past few years, you know, and there should be some deliberation there. I think and that between how to form, you know, create the law. The two different execution, creation, and then I think when it comes to interpretation, then there's nothing wrong with having a good discussion back and forth, you know, saying, okay, I see where this applies here and fits in this model, let's apply it here differently or otherwise. I think that's a bit more in line with the deliberative discussion that's intended, I think, by the system that we have. It's not as open and free, as you will, in the judicial one. I mean, the legislative has a lot more, you know, intent because they got to know the will of the people out there. But I think it still does show that there is a way to come to a good agreement, one that benefits the nation, if you will, and the people, by having deliberation, whether it be interpretation, deliberation, or creation or execution. And I think on the other two bodies, you don't have that right now. And I think the Chief Justice, one of many things that he's doing is saying, you all got to get back into this.
That seems like a
Sorry.
good positive note to end on
Yes,
this
welcome.
part of discussion. We're time flew by real quick, and let's talk about your service to the bar. Both of you have been very involved in the bar, and just for those who aren't lawyers, that's the collective of lawyers in the state. And we have some division as to age, and I know Victor was the young lawyers. Are you no longer a young lawyer?
He is still. He's the immediate past president.
Yeah, I'm hanging on. I have the gray hairs. As immediate past president, I'm no longer young, but because I was in there, I'm hanging on to it, Judge. I'm hanging on to it. But you know what a lot of people don't realize is there are over 100,000 attorneys in the state of Texas. About maybe a third of those are young lawyers. So those 36 years or younger, practicing 5 years or less, and so that's a very large group, probably one of the largest in the country of licensed attorneys, and we regulate ourselves, right? So any kind of grievances and that, those types of things, we regulate ourselves. And so it takes a big organization to make sure that happens, and then make sure we continue to have good continuing education and services to the public, access to justice, opportunities, and continuing education. But really proud of Pablo. Pablo kind of got me involved in bar service. I blame Pablo for all that. But I think it's important for us to get involved and not just pay our dues. There are plenty of sections within the state bar, affinity groups, and I think by participating just with elections or with any kind of social activity, profit groups, it's important to get involved and give back. I think there's a lot to be gained and given in that.
I agree, Judge. I know we're kind of short on time here, but my twofold sort of explanation about that, Judge, is that, on a very professional level, I've done 22 years of services at a legal aid organization. We provide free legal services to people that cannot afford it, to the poor. I think that's a basic tenet of our democracy, access to all, for justice. So I'm very proud to be part of that. But it was difficult for me when I started 20 years ago to come out and tell the private practitioner, you got to give us some pro bono assistance when they knew nothing of me. So my involvement at the local bar level, was that because I wanted them to know more about the organization. I wanted to identify better with my community. And that led to the state bar, activity, became the chair, the first chair of the board, who was from a legal aid or background, the first one since 1950 from the Valley. Since then, there's been one more as chair of the board. Then I also chair the Commission for Lawyer Discipline, which oversees the disciplinary system in the state of Texas. I think I'd be the only person from the Valley to serve as chair of the board and the Commission for Lawyer Discipline. and ran like like Victor said here, 18,000 votes into it, lost by 37 votes. But I did it because of the same issue that I wanted to kind of have the private bar know about the public interest attorney and vice versa, right? And I think the campaign itself might have pushed that forward. Plus, I wanted people to know, people knew when I walked into anywhere in Texas when I was campaigning for state bar president, I'm a legal aid attorney from Hidalgo County. That more than the bad news that people hear about the county comes out, that there's something positive about that. But on a very personal level, people don't know, might not know that I was born in Mexico, in Reynosa, right across the way. I was 5 years of age when my parents moved over here, first to go to law school, college and law school. And I've done nothing but legal aid work. I can probably make a bit more money and be rich about it. But I think there's no better way to give back to the democracy, to the nation, and the place that's kind of helped me, me where I'm at, than by doing the work that I do. So and I think I give back also at the same time to my profession by doing this bar work. For me, it's twofold, both because of work and recruitment, but also because I respect, how much this, the nation and my profession has given me.
Hey, Judge, if I could add one last thing, I know we're running out of time, but I'd like to add this just to kind of tag on what Pablo was saying. A great quote from the late Justice Damian Keith out of Michigan. He says, "We're all walking on floors we did not scrub. We're all walking through doors we did not open. So wherever you go, scrub floors and open doors." And I think by, getting involved in bar service, especially for our attorneys in Hidalgo County, there are plenty of opportunities to give back. We've been given great opportunities. It's on us to kind of give back to the community, especially with, like Pablo was saying, pro bono service, access to justice.
Great quote. So I encourage everyone, let's scrub some floors then for everybody else. If we can, if we're in this, might as well do something good for our community. And thank you very much, both of you. There weren't that many questions, and we can just answer later. I can come on and answer those questions. You've already given too much of your time, but I really appreciate that. I had a lot of fun having this discussion. I hope I wasn't too biased on anything that would make me recuse myself in the future. But it was fun. I really enjoyed it. Hope you guys enjoyed it too. Hope everybody who was watching enjoys it. Our next open forum series will be in 2 weeks. We're still polishing details about what's going to happen. We may have some surprises for people that have been following me on Facebook and on YouTube about that one. But I assure you, whatever it is, it's going to involve more great people like Victor and Pablo coming on and talking about issues that are important for our community. And then I'm very glad to use this platform from the bench to bring them to the people's attention. So thank you all very much. I really appreciate it.
Thank you,
and
Judge.
have a good night, everyone.
Good night.